Section 36 to consummate marriage. A decree, Section 36 of the Matrimonial Act, a decree of nullity of marriage shall not be made on the ground that the marriage is voidable by virtue of Section 5 sub 1a of this Act, unless the court is satisfied that the incapacity to consummate the marriage also existed at the time when the hearing of the petition commenced.
Okay.
And that the incapacity is not curable. That's subsection A.
Okay.
And subsection B, that the respondent refused to submit such medical examination as the court considers necessary for the purpose of determining whether the incapacity is curable, or the respondent refuses to submit to proper treatment for the purposes of curing the incapacity.
So if he submits,
that means it's not even enough to even say you cannot consummate. There's a further part to it. Are you being
so? If you are saying that you want to say marriage is null and void because the party cannot consummate, the question is, at the time the marriage started, the person could not consummate. Now, can the person consummate?
Yes.
If, for instance, at this time the person can now consummate, you cannot say it was null and void because now you have performed the magic you did not perform before. Secondly,
this law is just trying to save as many marriages as possible.
Which is
that is why we are telling you
it's good for the greatest number.
It has this perpetual nature.
No, what is even the law? The law is the greatest good for the greatest number. If the law perpetuates divorce in the highest number, is that the greatest good for the greatest number?
So save your marriage.
To foster peace.
You don't want to save your marriage. Which peace? How can you foster peace? There's something about society, which is ability to coexist.
Yes.
So if you cannot coexist with one person that only you decided to coexist with at a time, how do you coexist with other people? So you cannot foster societal peace.
But however, what the law has said, let's go straight into the law, because the way someone is going, she's drawing us a lot into personal emotions,
which we have been doing all over.
We've not been doing it all
even
over.
cited personal issues
For purpose of learning.
Yeah.
Now see what the law has said. If at the time they got married, they could not consummate, party could not consummate, and now that you are filing the petition, you can now, the person can now consummate.
Sometimes by virtue of training.
Yes. You cannot say.
Mone is the tutor. That's training,
Listen, you cannot now say that the marriage was a nullity. Secondly, if that incapacity to consummate
is curable.
For example, a woman that cannot be assessed, they can fix it to assess the locus equal. It's curable. Or a man that could not be erect can be adjusted, not by marine powers anyway, by whatever means. You know, some are psychological.
It's a state of
some might be psychological. So if there's a psychological, there's a way you talk to a man that will make the man continually be unable to get erect. There are men that cannot get erect around particular women.
Yeah.
Because of certain psychological,
and there are marriages that suffer these things.
Yes.
There are marriages that suffer these things.
Yes.
It's true. So once there is now a cure, let's say you now begin because the man might be thinking he cannot consummate.
Okay.
Until one day somebody now they now realize
this is the work.
you understand?
There are some places you perform better.
Just like how you leave some marriage and then go and have children somewhere else.
Where he could not have in his house.
Yes.
Different things. So that shows it's curable. Once it's curable, then it does not mean it will now nullify the marriage. Then, except where the person now, one, if it's curable, you cannot nullify. But if it's not curable, you can nullify. Then, if the person does not submit himself to treatment,
medical examination
for
purpose of determining the curability or incurability,
that is where you can now say it should be dissolved for nullity.
He's not ready to have the marriage.
But if the person has submitted himself, that means you cannot say it's a nullity. If the medical examination has shown that it's curable, then you cannot say the marriage is nullity. It's actually something that the law is actually looking for the greatest good,
Yes.
for the greatest number.
It's like the 2 minutes manner that has now been taking a go, at least I mean.
Okay, so we had that already. So that's section 36 sub 1 ABC. Now section 36 sub 2 says a decree of nullity of marriage shall not be made on the ground that the marriage is voidable by virtue of section 5(1)(a) of this act, where the court is of the opinion that A, by reason of I, petitioner's knowledge of the incapacity at the time of the marriage. Sorry, I restart again. The decree of nullity of marriage shall not be made on the ground that the marriage is voidable by virtue of section 5 sub 1(a) of this act, where the court is of the opinion that A, by reason of I, the petitioner's knowledge of the incapacity at the time of the marriage, I, the conduct of the petitioner's marriage, I, the lapse of time, B, or for any other reason, it would be in the particular circumstance of the case. It will in the particular circumstance of the case be harsh and oppressive to the respondent or contrary to the public interest to make a decree.
To make a decree of nullity.
That is,
This has increased the powers of the
you
court.
knew before. You knew before that you cannot consummate.
Because of money you enter.
Then 3 months later you want to go.
I'm telling you, 200 million.
You is now he.
No, the most likely events of failure to consummate is the male now. Let's look at it realistically.
Speaking statistically.
Yes, we have like 70% male who cannot consummate, 60% because a man that did not even have a vagina, they create it for him and he begins to consummate as a woman, transgender.
Which we can't really speak for because you don't know what that's like.
What are you telling me now? We have the physical experiences now.
You are witnessing.
My friend, I'm talking about that. I'm not saying I've experienced it personally. I'm saying that there are men who have switched on transgender who now have sex as women.
Which
Do you
again,
get?
I'm
So
saying,
if there is a woman that already has an organ that is not accessible, there should be medical resolution for that compared to a male that cannot consummate. That's what I'm saying. We have about 70% male who cannot consummate compared to the females, like 30% ratio of females. So that's why I'm just responding to that highlight she's raising.
See that me, like if you apart from statistics, looking around, I've not even heard the situation where the man
Cannot consummate.
that's statistics.
And what do you want to use to get information other than statistics?
Maybe because they're not reporting it.
I mean, the men are so kind.
You mean kind men talk a lot.
Oh,
So who is not
no
reporting
one
now?
are reporting now. Literally.
You are appropriating and reprobating.
That's what you are doing.
You can't just make a claim and say 70%. That's so huge. Look at the margin. It's so big. How can you say 70%?
I don't know. You buy your ABA.
Okay, let me ask you a specific question. Can you consummate?
I want to know.
We talk about the fact that they are men. We
Their
talk
men
about the
cannot
fact
consummate.
about the men that cannot consummate.
Very seriously.
Even this 2 minutes talk and 2 seconds man.
Yes.
If they are the origin.
What do you mean?
Meanwhile, the women.
And now we want to kill ourselves.
Maybe
No,
because
do
they're
you know
But now I
that?
just realized I don't even need to kill myself anymore.
No, do you know that the women do have this circumstance of 2 minutes? There are 2 minutes women.
Yes.
Can we go to
They are inactive
7?
women.
Yeah.
But let's not go into those details.
We have women.
So we have said that if the petitioner knew of the incapacity at the time of the marriage, the petitioner cannot rely on that for nullity. If the court feels that the petitioner knew, if the court feels that the conduct of the petitioner since the marriage will cause harsh and oppressive conduct on the respondent, you get the way the woman go dey behave. That is harsh and oppressive on the male, or the way the man behaves that is harsh and oppressive on the woman, then that same man that is using that harsh, because whatever it is, if somebody has a natural defect and you now play it on that person in a harsh and oppressive manner, then you now still petition to dissolve because you say you will continue. You will continue, especially one if you were aware. Then you now want to now be harsh and oppressive on such a person.
Why are you just looking for avenue to divorce earlier?
You understand? Or where it is contrary to public interest.
Yeah, it's not fair.
Maybe you're the one that caused the incapacity.
Who is the who? You are the you. But I cannot cause any
No,
incapacity.
it's not you I'm talking to.
The person,
Maybe the man.
Use petitioner or
Maybe
respondent.
the woman insisted that they
Are you
go.
checking the law? Yeah, checking the law.
The woman insisted that they go on a trip, and then they now, unfortunately, the man.
insisted. The first man they do something.
Seriously, the woman insisted that they go on a trip, and then the man they had an accident.
That is how the woman's fault.
You understand? They had an accident that now affected the man. Then the
Blame
woman,
me.
the woman now is now being.
Meanwhile, he
This
was
will
the
not
one
go
driving.
relate because we're talking about nullity. What dates back to before the marriage?
Even before the marriage, it can happen now.
So nice.
Do you understand?
You were driving.
Like
you
they've been doing this thing together. You understand? But even just before the marriage, something
That
happened.
made it impossible.
But then I will not marry him now.
Can you
You
imagine?
said before the marriage.
Okay.
This one marriage has happened, but the marriage is not. That's what we're talking about.
Then where they talk of lapse of time, I think we read the section that talked about the time frame.
Or for the consummation, 1 year.
No.
1 year.
No, I didn't. I wasn't.
There's something on 1 year now.
6 months
Is that 5-1?
lapse of time. All I see here is an attempt to save marriages.
Which is in the best interest.
Just
Which I don't disagree with, to be honest with you.
Would the lapse of time relate to?
Anytime they decide to consummate the marriage.
Okay, I think that lapse of time will be the discretion of the court to look at, okay, how long has it been? Is it 72 hours like the likes of Otobo?
Yes.
You understand?
Because if it is something that is just a
I
short
think-
while, it
Yes,
can be something that can adjust.
yes. Because the law has already
Or it's not even up to 1 year.
yes,
So let's wait for the 1 year
to complete.
to be complete. But my worry is this issue of public interest because it will now look like if something will bring disputes to the person of public repute, will the court now not grant certain things because that this is the reason? Looking
Yeah,
at
for
I don't
example,
really think
for
that's
example,
what-
a sitting governor.
I was going there, but
please, can someone check public interest online? The meaning of public interest to make a decree contrary to public interest.
I'm wondering how public interest will play into
Yeah,
the
so we need
quality
to
of
check.
marriage.
Public interest means something that is generally beneficial, important, or necessary for the well-being, safety, or prosperity of the general public, rather than for a specific individual or private group. It usually refers to matters that affect society at large, such as health, security, justice, economic stability, and environmental protection, and is often used as a guiding principle for government decisions, legal rulings, and policy making. In short, if it serves the good of the community as a whole, it is in the public interest.
So how can even a governor be having to do with the public? Is it that
I don't want to go
is
political.
it that Delta State will not be looking at Bayelsa State somehow? If
No,
the
that's
Bayelsa
not.
State governor,
No, that's
Talking
not
about the
the
general public interest.
I've seen public interest from what he has read as something. What will be the effect?
that's what I'm saying.
What will be the effect? Negative effect.
Trying to look at it from like a criminal angle.
What will be the effect? And it's looking at the public than the individual.
If it's okay.
What if there is a customary law that a king should be married and the person is a king, and now they want to that will not work.
I've never seen a Nigerian king we get one wife, Charlotte.
Public interest.
Negative effect of public interest. Is that what we are looking at now?
No,
We're
I'm just
trying to
saying.
get the effect with relation to this section.
Nullity, a decree of nullity of marriage, not be in the interest of the public.
Public
I think that
interest.
there's no way to look at this without looking at the circumstances and the parties involved.
Okay, what I think, one way or the other, this particular provision relates to nullity and not dissolution of marriage. So if it will be contrary to public interest, let's say to bring disrepute to the person, maybe because of his status in an environment, to say that a medical condition
Is the basis.
is the basis for the nullity, that the marriage was null and void. it can be the basis to dissolve the marriage. But to say that that's the basis why the marriage is null and void
Not be fair
will not be fair.
to the public here.
Now, let me just come
Yes,
on
what
this.
is it?
A marriage is not in favor of public interest. It refers to a marriage that, by its nature or circumstances, is considered harmful, undesirable, or contrary to the well-being, morality, or stability of society.
Exactly, like say a brother marrying a sister,
In
for
law,
instance.
especially in family law, public policy, or marriage laws, this can mean contrary to legal provisions, that is bigamy, it's against public interest, and against moral standards. Marriages involve coercion, fraud, or exploitation, and harmful to societal order, such as sham marriages, entered solely from immigration fraud, money laundering, or avoiding legal duties, then undermining rights, for example, where one party is underage or mentally incapable of consent, then political or security risks. In rare cases, such unions may be seen as jeopardizing national security or public safety.
All right, I think that's fine. No need to hammer too much. But however, one thing we pick from here is that it is at the discretion of the court to be in the at the discretion of the court to look at the circumstances under which it will now consider to grant a decree of nullity. But we have seen harsh and oppressive circumstances against the respondent. It should not be harsh, whatever it is, it should not be oppressive. Because it might be
You need to be
in a way
modest.
to undermine the person. Maybe the purpose of filing the suit. One, the person already knew that the marriage, the person could not consummate or something. But now, the person just wants to do it to bring the person into public disrepute. Especially like in the first circumstance, I said the petitioner was aware. You knew of it in the first place. But now you just want to do this thing to actually oppress and bring the person to public disrepute. Maybe because of the person's current public standing. So meaning I can bring a defense to say that the intention of this suit is to undermine my personal capacity at this time. So
There are sometimes there's some certain situation you think you can manage or deal with. For you to realize after some time.
you cannot
But do the solution of marriage, not
to say that it was a nullity ab initio. Okay.